which side?
He is always here.
No.
This-
Whether you are on a fence or
Genuinely, personal opinion, one shouldn't take extreme position.
Who are you appearing for?
Where the
Intervenable.
interventions have been allowed on the first place.
Okay.
We are giving advice to the President of India. I think we
No,
should-
not we. Court. The court is giving. Yes, sir. No. No, the 143 empowers only the court to give advice
Then
to the president.
Then without your assistance, we cannot give our advice.
Assisting the court. My lord. We are not advising the government. Yes.
Well, may I just put this down because we can't see your lordship, Mullah. We'll put it back, Mullah, at the end.
Even the solicitor.
Yes.
We will
And-
not put it back as long as the CV goes on.
Your lordship, because here there is no petitioner and respondent. And genuinely, I am saying this, my lord, without any other meaning. Mr. Sibbal, my lord, I am looking forward to his arguments because he has been a parliamentarian. He has been an elected person answerable to the people. And my lord, we know
So he has been a person answerable to the parliament also.
Parliament, that's why I was coming to that he was also in the governance and how it affects the governance when I come to, my lord, the question of judicial review or, my lord, justiciability. Because people, your lordships are aware of late, my lord, since last 20-25 years, my lord, you cannot take a voter on a ride. They catch the elected people.
You cannot.
Take voters on a ride, which earlier used to happen. They catch you that I have this problem, you are not solving me. And that is why, my lord, I always say that irrespective of the color of the political party, an elected person cannot be denounced that he is just an elected person. And
But who says that?
I will show. I'll show who said that, my lord. I'll not going into, your lordships have not said. Your lordships have not said, my lord, but I'm going to show that, but they are answering.
I have always said that
My lords have always said, I have,
separation of power and
this bench I'm not referring to, my lord, when we say,
I have so many times deprecated I have said that the judicial activism has to remain, but it should not turn into judicial terrorism or judicial adventurism.
terrorism or judicial
And
adventurism, my lord, that's correct, my lord. And as rightly submitted by Mr. Shankar Nayan, we are to assist your lordships, my lord, and your lordships will give the opinion. My lord, so far as yesterday's argument, my lord, which I will not stretch it beyond it because I know your lordships have got, my lord, what is my interpretation
Yes.
of Article 200, but I have tried to, my lord, kind of calibrate it, my lord, so that instead of, my lord, is better, my lord, explained by me the way I am reading it. And it's very easy chart, my lord. It would not sorry. My apologies. I thought I had given. Yes,
Share it.
I can share digital also. Share digital also. Rest of it is shared with on digital, this thing, for rest. Oh, your lordships, my lord, kindly, my lord, bear with me only for 5 minutes and I'll switch over to the next point. The governor shall declare, I'm not repeating declaration has its meaning, it's a constitutional declaration. He has 3 options. First, let us come to the first option, grant assent. Now, what are the facets of granting of assent? Lord, please see the left-hand side route which the governor can take. At the outset, he grants assent. The bill becomes Senate. Correct, my lords? But he can defer grant of assent and take a decision to resort to the proviso, that is returning the bill to the House. That is the 4th option in the proviso. Bill is returned by the House to the governor with or without modification. Then he will have 2 options. Lord, if your lordships can. Then he will have 2 options. He can grant assent. That's all right. My recommendations or whatever.
We have gone through the chart. These only debates what you argued yesterday.
My lord, but my lord, second, my lord, let me at the cost of repetition show what is second. Second is a withhold option, which in my submission is a standalone option, and it is a complete action of the constitutional functionary.
So according to you, Punjab has been wrongly decided.
Yes, my lord, but he has a choice. My lord, right side, at the outset, if he withholds for, my lord, reasons, my lord, which I have explained, some things is so patently unconstitutional or something going against the nation or clearly in the first schedule, etc., then the bill falls through. Now the question was, instead of, this is where instead of comes, instead of taking this route of at the outset withholding, resorts to the proviso instead of withholding. Then, my lord, it is returned to the House. And if it comes back, he will have two options, my lord. He will grant assent that, okay, I'm bound because I cannot now withhold because I have resorted to the proviso. Or he can reserve the bill for consideration of the president. My lord, third is there is one new element which, my lord, which I have, and there cannot be any dispute on this element. When he reserves the bill at the outset for the consideration of the president, for presidential assent, my lord, first can be in case of repugnancy. If he feels that it is repugnant to some central law, he will refer it. Second column, my lord, which is a bigger column, your lordships did not read. There are certain provisions in the constitution itself which mandates that if your state legislature is passing this law, mandatorily presidential assent is required. It's nobody's discretion, neither governor nor council of ministers, nobody. My lord, for example, Article 31(3), 31A, before amendment, then second proviso to Article 2, so and so, so and so, so and so. There are several provisions. Or any other reason, my lord, which he feels that I want to reserve it for the president. Lord, this is what my lords also, my lord, were pleased to, my lord, indicate. This is just to, my lord, calibrate it, my lord, and put it in a comprehensive manner. But all four options are independent of each other. At least 1, 2, and 3 are independent, with an option to resort to option 4, not a mandate to resort to my lord, option 4 as decided in Punjab. So that is my case, my lord. Now, my lord, may kindly come to sort of page number.
Second meeting, you can choose to resort to the. Should your arguments, you have.
That argument is over. I'm coming to the next. Well, look, there are some judgments which I have cited, how proviso is to be interpreted, but I don't wish to cite it here. It's a fairly settled proposition, and your lordships are fully aware. It is cited for ready reference.
Very well-known phrase.
Yes, yes. My lord, so page 187. My lord, this is the second question, my lord, which I am addressing. The first part is over. 200 and 201 is over. Whether governor is bound by the aid and advice tendered by the council.
That is page number?
187, my lord, of my written submissions. So PDF page also same.
PDF page is there.
Your lordships have
Yes.
PDF page or the physical file, my lord. I can accordingly. The PDF page is 94. Para 166, my lord. जब मैं आऊं तब याद करो जब वहां पे पहुंचू तब याद करो Lord, the question is whether the governor is bound by aid and advice of the Council of Ministers, my lord. Lord, 163 I have read, my lord. I'll read the first part, 163.1, so that, my lord, for just immediate reference, there shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under this constitution required to exercise his discretion or any of them in his discretion. Correct, my lords? So functions can be discretional, based on discretion, or as per aid and advice. My lord, what is the demarcation? That is the question, my lord, before your lordships, my lord. My lord, here, minimum, my lord, I'll skip what is not relevant, but the minimum constituent assembly debate, my lord, which is relevant for your lordships to consider the question, my lord, is at page 187, bottom. My lord, Mr. Kamath objected this discretion, and it was answered by Mahavir Tyagi. Lord, please have a look at Mr. Kamath's objection. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified this clause by saying that the president is bound to accept the advice of his ministers in exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor. And to me, it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to tenets of principle of constitutional government, which you are going to build up in this country. It would be wrong, I say, to invest a governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for reasons of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. Then, my lord, this argument is responded to by Sri Mahavir Tyagi, lord, which is here. I beg to differ from my honorable radical friends, Mr. Kamath and Professor Shibban Lal Saxena. And I think the more powers are given to provinces, the stiffer must be the guardianship and control of the central in the exercise of those powers. That, in my view, we have now given up the old idea of creating autonomous states and are now keeping a reserve of powers in the center, and we are going to have nominated governors. Those governors are not to be there for nothing. After all, we have to see that the policy of the center is carried out. We have to keep the state linked together, and the governor is the agent, or rather, he is the agency which will press for and guard the central policy. In fact, our previous conception has now been changed altogether. The whole body politic of a country is affected and influenced by the policy of the center. Take, for instance, subjects like defense involving questions of peace or war, of a relationship with foreign countries, of our commercial relations, exports and imports. All these are subjects which affect the whole body politic, and the provinces cannot remain unaffected. They cannot be let free of the policy of the center. The policy which is evoked in the center should be followed by all the states, and if the governors were to be in the hands of provincial ministries, then there will be various policies in various provinces, and the policy of each province shall be as unstable as the ministry. For there would be ministries of various types having different party levels and different programs to follow. Their policies must differ from one another. It will therefore be all the more necessary that there must be coordination of programs and policies between the state and the central government. The governor, being the agency of the center, is the only guarantee to integrate various provinces or the states. The central government also expresses its thought, itself, through the provincial states. Along with their own administration, they have also to function on behalf of the central government. A governor shall act as the agency of the center, and we'll see that central policy is sincerely carried out. Therefore, the governor's discretionary power should not be interfered with. Democratic trends are like a wild beast. Say what you will. Democracy goes by the whims and fancies of parties and the masses. There must be some such machinery which will keep this wild beast under control. I do not deprecate democracy. Democracy must have its way, but do not let it degenerate into chaos. Moreover, the state governments may not be quite consistent in their own policies. Governments may change after months or years, with them will change their policies. The governors may change too, but the policy and instructions given by the center to the governors will remain practically unchanged. The more the powers given to the states, the more vigilant must be the control. The governor must remain as the guardian of the central policy on one side and constitution on the other. His powers, therefore, should not be interfered with. He is not for nothing. He is not just a showpiece. My lord, thereafter, your lordships may kindly turn the page, my lord. Pandit Thakur Das Bhargav, my lord, continues the discussion. Sir, I beg to propose the amendment of oppose the amendment of Mr. Kamath. Under Article 143, the governor shall be and in the exercise of his functions by the Council of Ministers. It is clear so far. मुझे देना ये कुछ कट गया है मेरा. Article 143, governor shall be aided in the exercise of his functions by a council of ministers. It is clear so far. I gave notice of an amendment which appears on the order page at so and so, which I have not moved. In that amendment, I have suggested that the governor will be bound to accept the advice of his ministers on all matters except those which are under this constitution required to be exercised by him in his discretion. My submission is that it is wrong to say that governor shall be a dummy or an automation. As a matter of fact, according to me, the governor shall exercise very wide powers and very significant powers too. If we look at Article 144, it says the governor's ministers shall be appointed by him and shall hold office during his pleasure. So he has the power to appoint his ministers, but when the ministers are not in existence, who shall advise him in discharge of his functions? There can be a vacuum. One ministry goes, another has not been installed. In that context,
whenever there is a president's rule,
yes, yes,
there are advisors to the governor.
Correct. They're appointed by the center. But can we read further?
In the vacuum also, normally if one CM resigns, or if he loses a majority till the new CM takes, he acts as a caretaker chief minister.
No, sir. Kindly, my lord, have a look at this one. Suppose, my lord, the tenure has gone. The governor tenure doesn't go. The new election takes place. It is considered. And it is considered subsequently in judgments also. My lord, 7 judgment, my lord, considers this aspect. Then again, when the governor calls upon the leader of a party for the choice of ministers, after a previous ministry has been dissolved, in that case, there will be no ministry in existence, and who will be there to advise him? Therefore, he will be exercising his functions in his discretion, as well as people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly conferred by this constitution. He will be a man above party, and he will look at the ministry and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is a mere dummy, an automation, or a dignitary without powers is perfectly wrong. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. But there are many other matters in which the advice will neither be available, nor will be bound, nor will he be bound to accept that advice. My lord, thereafter, my lord, Dr. Ambedkar's speech, which I have read, my lord, in a different context, So, my lord, I am not reading it here, but he, my lord, substantially echoes the Mahavir Tyagi view and the view of Pandit Thakur Das. Now, my lords, may kindly come to Lord, I have quoted Sirvai, my lord. If your lordship can come to, I will not read it. Page 192. My lord, what are the discretionary powers of the governor and the president? My lord, Sirvai has, my lord, H.M. Sirvai has elaborately dealt with, my lord. I may not read it. Your lordships may kindly read it. It would, my lord, really assist your lordships. Now, please come to, my lord, 194. Lord, these are the judgments on the question of discretion. Lord, please see 188 at the foot of page 194. It is, your lordship gets that? No? It is 194.
What?
194. PDF is 101. Para 188. It is submitted that this honorable court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so-and-so, 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 where he will not be bound by the aid and advice and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchi Commission and have been concurred by a 5-judge bench of this honorable court in Nabam Rabia. I'll read, my lord, very illuminating paragraph of Nabam Rabia, where the constitutional courts specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent Chief Minister and his Council of Ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of Council of Ministers, like the case of grant of sanction for prosecution of Council of Ministers. 197 sanction or Section 17 PC Act goes before the governor, my lord, in case of chief minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Samsher Singh. Samsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Samsher Singh's 7-judge bench judgment is taken note of in state of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the, it's not there, my lord. I can't, my lord, in state of Punjab versus Union of India, the 3-judge bench, my lord, 2024 judgment, takes note of Samsher Singh, but it has escaped the attention of the bench of these 2 paragraphs, which according to me is the real law of them. Lord, your lordships would find, my lord, that judgment at page 11669. Just put a note, my lord. That judgment, my lord, volume 5.29, judgment starts at page 11660.
Volume?
volume 5.29, at page, it starts at page 11660. Shamsher Singh is cited at para 16,
Para 16.
16, at page 11669.
1 minute.
Not only two paragraphs are noticed. The lordships may come to 11669. My Lord Justice Narasimha has, my lord. Para 16, my lords have. My Lord the Chief Justice.
Does it start from 11660?
It starts from 11660, but I am at 11669, where Shamsher Singh is noted. These principles have been well established, Your Lordship gets, my lord, since the decision in Shamsher Singh versus State of Punjab, where this Honorable Court held, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisers to bear responsibility for his action. Those advisers must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, your lordships have, my lord Justice Suryakant has the right copy, my lord, I believe.
It's supposed to be.
I thought so, my lord. My lord, volume Roman 5, 29.
From Allahabad, there's nothing there.
11,670 पेज खोलिए.
My lord, can I give my copy for immediate reference? My lord?
यानी मिल गए.
State of Punjab versus governor.
No, like, yes, go to.
My lord, 11669,
Paragraph 16.
paragraph 16. My lord, I'm grateful. My lord, where
Shamsher Singh.
Shamsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread it, my lords? Or may I my lord, read them again?
Yes.
Yes. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisers to bear responsibility for his action. Those advisers must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. These two paras are quoted. What is missed from Shamsher Singh is in my written submission at page 197. These two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of some shared thing.
And this is what I'm now showing.
54 and 55 you want to.
And it's a, Samsher Singh is 7 judgments.
Statistics.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, so-and-so, 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the Constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion, even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers. In other matters where the governor acts in his discretion, he will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. My lord, now I'll come to that, my lord, and my learned friend also will take assist your lordships on that. My lord, in the judgment of Tamil Nadu, now, my lord, next judgment is MP Special Police Establishment Act. Again, my lord, 5 judges, and was not noticed by the state of Punjab judgment. Para 11, I'll skip, my lord, the first part. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. In criminal Constitution of India expressly provides for contingencies, so-and-so, so-and-so, so-and-so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion, even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Samsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. My lord, para 54 to 56,
Which you just read.
which I just read, which my lord, appears to have escaped the attention of the bench in State of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is, my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. My lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in State of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchi Commission's formulation that governor's discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. But 151, the important observation in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled. The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, 5-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163, we endorse and adopt the same as a correct expression of constitutional interpretation with reference. This is 151, 152. Lord, this Nabam Rabia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords.
Which para?
My lord, page 12432, para 301. The lordship gets, my lord. 11301. Lord, another constitution bench of this court in Nabam Rabia had the occasion, my lord. Thereafter,
One page number?
I'm sorry, 12432.
Yes. Paragraph.
12432.
Yes.
Para 301. Another constitution bench of this court in Nabam Rabia. Nabam Rabia is, my lord, taken note of. Then, my lord, the honorable court is pleased to quote 140, para 147.1, 147.2, 148, 149, and at page 12435, Lord, matters and possibly misses 151 and 152, which I read, and comes to 154. These two paragraphs, my lord, since, my lord, it escaped the attention of the two-judge bench, my lord, I am placing for your lordship's consideration. Now, my lord, I come to the next judgment, that is B.K. Pavitra. But this is two-judge bench judgment, which is declared.
Just 1 minute. Come back to page 12432. Refers to paragraphs 147, 148, 149, and then it jumps to paragraph 154. 151 and 152 are left out.
That's what I submitted, my lord, with profound respect. That two paragraphs seems to have escaped the attention of the bench, my lord. Because from 149, it directly goes to 154. And in my submission, the real law is laid down in 151 and 152. And this is, my lord, while discussing discretion, the point which I am arguing, my lord, whether in all cases aid and advice is binding or there is a room for discretion.
Yes.
Lord, now please come to page 200 of my submissions, my lord. B.K. Pavitra judgment. Lord, this issue was squarely there.
Can you
This-
read 154 with Tamil Nadu refers to? Underline. Comes after 152. They same very page. 154 of Tamil Nadu follows 151 and 152.
Please maintain that though.
Oh, Lord,
the paragraphs are
154 is Nabam.
वो दो missing.
चार paragraph
बाद में
151 and 150.
Lord, 154 is slightly different from 151, 150. It is not slightly, but not substantially. Lord, now kindly come to B.K. Pavitra. Page 200. This is, of course, a two-judge bench judgment, but it is declared per incurium. And I'm not repeating the argument, my lord, but this itself was sufficient enough for a reference under 145.3. Lord, apropos your lordship's very correct, my lord, the proposition, my lord, the Chief Justice says at the outset that in every matter we are not supposed to look at 145(3).
But
at the
so far as justiciability is concerned, paragraph 155.5, Ebam Revia.
Yes, madam. But 155 will have to be read in context of 151,
Yes,
150.
but then even you read 155.5.
Fifthly,
One, two,
the underlined portion, highlighted part. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 162 is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission, but this is on judicial review, not on discretion. Rejected advance by the respondent that the scope and extent of discretion vested with the governor has to be ascertained from Article 163(2) on the basis whereof the submission was canvassed. And secondly, any discretion exercise beyond the governor's jurisdictional authority would certainly be subject to judicial review. It was on judicial review. And it is, if it is beyond, but not obviously, if governor.
According to you, under 200, he has an ample discretion.
That's
And
what
therefore-
Nabam Rebia says, my lord. And my lord, that's my contention. He has ample discretion, my lord. Situations may differ. The instances which are given in all the judgments are illustrative, not exhaustive. But they say that it is wrong to say that in every matter, like precedent, he is bound in every matter by aid and advice of the Council of Ministers. Samshay Singh also, my lord, 7-judge bench says that there are discretionary areas, including Article 200. Specifically, Article 200, every constitution bench mentions. That was precisely, my lord, the question in Tamil Nadu. I'm not, my lord, deviating from this point, but, my lord, just to, my lord, kind of respectfully respond, my lords have very rightly said that in every case, it's not necessary that the court would examine 145(3). A bail petition comes, it would involve Article 21, but it won't become a constitutional interpretation question that it has to be referred to the larger bench. But this was a case where only issue was constitutional interpretation. Facts were not, my lord, much in dispute. Anyway, my lord, leave it at that. Please come to BK Pavitra. My lord, para 66. This is, my lord, declared to be per incurium by the 2-judge bench, my lord, in Tamil Nadu. I'll show, my lord, that. Where a bill is not a money bill, your lordship gets. Where a bill is not a money bill, the governor may return the bill for reconsideration, upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to the bill, but necessarily reserve it for the consideration of the president if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the president, a discretion is conferred upon the governor to follow one of the courses of action enunciated in substantive part of Article 200. Aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for consideration of the president, the substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for consideration of the president. The Constitution has entrusted this discretion to the governor. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia versus so-and-so, where, my lord, 154 is quoted. My lord, I've read, I'll skip that. Then para 67 of BK Pavitra. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for a consideration of the president. They did not give instances. They left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the President. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state
Lord, I would
legislatures
respectfully, my Lord,
represent the
request your
popular
lordships
will
to
to
take
those
volume
who elect their
V17,
representatives.
517.
They are the collective embodiment of the will. The act of
Page
reserving a bill for
6664,
assent of the President
6664.
must be undertaken upon
This is
careful
Kesare Hind
reflection,
judgment.
upon a doubt being entertained by the governor about the
sorry, not
constitutional
V5,
legitimacy
Roman
of the bill
My
which has
mistake.
been passed.
Page?
Article 200 contains
664.
the source of the constitutional
664.
power which is conferred upon the governor
This is Kesare
to
Hind,
reserve a bill
Constitution
for
Bench judgment.
consideration of the President.
I'll just read
Article
three paragraphs.
254(2) is an illustration of the constitutional authority of the governor to My Lord Justice Suryakant has the same five minutes. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration.
17 May.
Then triple fifty.
Kesare Hind
Kesare Hind, yes.
versus NTC, yes.
Kesare Hind versus National Textile Corporation. So para 1, 2 and 3 gives what the issue was before the court. Short, your lordship gets one. Para 1. Short but important question involved in these matters is whether the assent given by the President under Article 254(2) of the Constitution of India with regard to the repugnancy of the state legislation and the earlier law made by Parliament or the existing law could only be qua the assent sought by the state with regard to repugnancy of the laws mentioned in the submission made to the President for consideration before the grant of assent, or would it prevail qua other laws for which no assent was sought? Your lordships would mark 254(2) is just, my lord, the cause for exercise of 200. 254(2) says that if there is repugnancy between central and state law, then President would go under 200 and seek assent. The contention is, once the President grants the assent to the state legislation, the state law would prevail on the said subject, and such assent would be deemed to be an assent qua all earlier enactments made by the Parliament on the subject. The contention is negatived for the reason recorded hereinafter. It is held that consideration by the President and his assent under Article 254(2) is limited to the proposal made by the state government. The state legislation would prevail only qua the laws for which repugnancy was pointed out and the assent of the President was sought for. Proposal by the state is a sine qua non for consideration and assent. Well, just to broadly point out, well, suppose the Honorable Governor feels that it is in repugnant to two central acts and forwards, my lord, for the assent of his Honorable Governor. But it is found that it was repugnant to 5 central laws. What would be the effect of the assent? And one of the main questions which arose was, can the assent ever be justiciable? I'm sorry, my lord. Yes. My lord, kindly now come to para 23. Para 23, my lord, 6673. The learned senior counsel, Mr. Nariman, next submitted that the assent given by the president is not justiciable and placed reliance upon the decision of this court in Bharat Srivastram Sangh versus State of Gujarat, wherein this court observed thus: it cannot be said that the assent which was given by the president was conditional. The records relating to the above proceedings were also made available to the court. On going through the material placed before us, we are satisfied that the president had given assent to the act, and it is not correct to say that it was a qualified assent. The act, which was duly published in the official gazette, contains the recitals that the said act had received the assent of the president on so and so. Moreover, questions relating to the fact whether assent is given by the governor or the president cannot be agitated also in this manner. In haste versus so and so, this court has observed we have no hesitation in holding that the assent of the president is not justiciable, and we cannot spell out any infirmity arising out of his decision to give such assent. My lord, now your lordships may kindly see, haste is again quoted, which I have read. I'll skip, my lord, para 25. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and the earlier law made by Parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. That is to say, merely looking at the record for which assent was sought would not mean that the court is deciding whether assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by the Parliament prevailing in the state, or it has sought general consent. In such a case, the court is not required to decide the validity of the assent granted by the president. In the present case, the assent was given after considering the extent and nature of repugnancy between Bombay Rent Act and Transfer of Property Act as well. President so and so. Therefore, it would be totally unjustified to hold that once the assent is granted by the president, the state law would prevail. No? That is on the facts of the case. Now, my lord, I would respectfully substantiate this submission, my lord, on the ground of doctrine of separation of powers, and, my lord, on the ground that non-justiciability of constitutionally coordinate organs is a part of separation of powers, my lord. And that is how, my lord, your lordships have construed. My lord, if your lordships can now consider coming to another angle from which, my lord, this can be seen. My lord, suppose assent is granted as per the aid and advice of the Council of Ministers. There is no dispute between the governor, the view of the governor and the view of the council. My lord, Article 163(3) specifically prohibits the court from examining what advice was granted. Consequently, as a consequence, it would also prohibit the Honorable Court from inquiring why and for what reason the assent was granted. This is one facet. Second, my lord, suppose assent is granted, justiciability, my lord, according to two judgments, it's not justiciable. Suppose the Honorable Governor chooses the route provided under the proviso that first I would send it back with a message, then even that would be subject matter of judicial review. After the proviso, my lord, operates and the bill is again presented to him with or without modifications, he may choose to refer it to the president. That again can be subject matter of judicial challenge. Therefore, my lord, my respectful submit, my lord, thereafter it would go to the president. The president also may again choose to send it back to the legislature under Article 201. That again can be a subject matter of challenge. Thereafter, my lord, the president may grant assent. That would also be a subject matter of challenge. My lord, the question is, in the scheme of things, my lord, when the governor and the president are exercising legislative powers, being part of the assembly and the parliament respectively, my lord, is such multi-pronged attacks by way of a judicial review is contemplated, And my lord, in my respectful submission, the answer is no. If your lordships can only come to my lord, page,
So see, if the assent is granted
yes, sir.
by the governor or the president, no question, because it becomes a law. If it chooses to go through the proviso, whatever, it is taken to the logical end. So either he grants assent or not.
Can I just interrupt here with your lordship's permission?
But if the governor withholds it for unlimited period,
No, my lord, again, I'm not repeating it. Withhold is permanent withhold. It's an act by,
permanent withhold, because
Yes.
from your chart, permanent withhold and temporary withhold.
yes, yes, there can be, that's a possibility.
Yes.
But, my lord, please see, my lord, the title of Article 200. It said assent of the governor. Assent is one. It has three facets: grant, withholding, reserving. So what, in my respectful submission, is not justiciable is exercise of powers under Article 200 and 201.
So according to you, 200 is totally beyond the scope of judicial review
It's,
and justiciability.
my lord, it is not justiciable. Not similar, again, contrary to the.
Justiciable in the sense, it's a decision and decision-making process. The decision is not justiciable, that why the president or the governor has assented to. That the court may not examine it. The court can examine this aspect if there is a question of repugnancy or question of constitutionality of law will come. There the court will not examine the assent, the court will examine the very competence of the legislation
And the act itself.
itself.
Act itself.
Exactly. Here the question is of decision-making process, not the decision ultimately taken. So in the decision-making process, the court, as the rightly observed by the question of bench, will call for the file, for what purpose the state had sought assent, to what extent, what were the laws. That process can be examined by the court. So it will fall within the ambit of judicial review.
My lord,
What is not justiciable is decision, assent, but process is
Lord, my difficulty is my difficulty means the difficulty which I foresee is multi-level challenges. For example, if grant of assent per se can be challenged, the option of the governor to send it, return it to the house also is a decision under 200. First option. That also can be challenged, that he could not have, because there is no repugnancy, or their governor can also send it without repugnancy.
that's also decision. Decision, it will not be challenged.
It cannot be challenged. That's my submission. Lord, suppose he chooses that I would refer it to the president for presidential assent. That is also a decision under 200. My lord, and all this, my lord, are isolated and independent powers, but can be exercised consequentially also. For example, Lord, a governor may say that right now I am not granting assent, I am returning the bill with amendment. The amendment may not be based upon repugnancy argument. He may just, the proviso say even desirability. The governor says that it is desirable that instead of, say, age is the subject matter. I am just giving a hypothetical example. Age is the subject matter. Then instead of 21 years of age you are fixing, make it 25. It goes back. That is a decision, again, my lord, subject to challenge if your lordship holds that it is justiciable. Thereafter, my lord, the parliament, the assembly would return it with or without, my lord, the acceptance of his recommendation. Then also his option is available. If it is repugnant or otherwise required to be referred to the President of India, he can again refer it to the President of India. At that stage also, my lord, if it is justiciable, it can be put to challenge. Same thing would happen when the bill is received by the President of India, referred by. The President may again send it back to the House that I am suggesting something else, or according to me, the governor has not found it, but I am finding it, there is something repugnant, and I am returning it back. My lord, there is no prohibition. The President can do that. That is a decision under Article 201. Lord, again, that would be justiciable. Therefore, my lord, my respect, coordinate constitutional functionaries are, my lord, outside the pale of justiciability. my lord, because if it is a grant of assent, my lord, the question of, my lord, challenge will not arise, because then the act will be under challenge. Act can be under challenge, my lord, and there is no difficulty about it. No? There cannot be any argument. My lord, kindly have a look at page 254. My lord, first 253. My lord, I have read it, but just for ready reference, Council of Ministers to aid and advise the governor. 253. Lord, it is always, my lord, safe to save the jurisdiction of the court, and I am conscious of that fact. But, Lord, as it would, my lord, I would try to make it clear subsequently, Lord, this theory, separation of powers amongst coordinate constitutional functionaries, is a theory accepted in our constitutional principles. Therefore, in case of 200 and 201, Lord, it is, according to me, my lord, non-justiciable. Lord, please see 163, Council of Ministers to aid and advise the governor. But please see 3, the question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. Kindly pause here for a minute, my lord, and let me give, my lord, one hypothetical example. My lord, the outgoing government has hurriedly passed a bill. It is sent to the governor. The new government is formed. The new government is not the same government. Some other party forms the government, or some other leader becomes the chief minister. He may even advise the governor to withhold the assent, that now I would like to have a fresh mandate from the fresh electorate, from fresh assembly. Lord, the constitutional prohibition is what advice he has given you cannot go into. So in my submission, as a consequence, what is done by the governor after that advice is also, my lord, non-justiciable. Court cannot go into it. Now please see, my lord, page 254, State of Punjab versus Sodhi Sukhdev Singh, where, my lord, 163(3) came to be considered by the constitution bench of this court, my lord. My lord, only highlighted part, my lord, may be read. It is hardly necessary to recall that advice given by the cabinet to Raj Pramukh or the governor is expressly saved by Article 163, sub-article 3 of the Constitution, and in the case of such advice, no further question need to be considered. The same observation falls to be made in regard to the advice tendered by Public Service Commission to the Council of Ministers. My lord, then next, my lord, 107, page 255. Under Article 163(3) of the Constitution, the question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. In view of the constitutional protection and the reason underlying such protection, I hold that in present case, the district court was right in sustaining the claim of privilege. My lord, this article itself, my lord, gives an indication that there are some communications amongst inter se constitutional functionaries which are put by the Constitution beyond the examination by the court. Constitution, my lord, Council of Ministers is also a constitutional body. Their communication with the governor, if it cannot be examined, my lord, then the governor's communication with the president also cannot be examined. And similarly, any exercise of power under Article 200 would be beyond judicial review, my lord, or rather would be just non-justiciable. I'll not use the word judicial review, non-justiciable. My lord, your lordships may, I'm just for reminding para 297, my lord, Kameshwar Singh and Valluri Chaudhary. My lord, Kameshwar Singh and Valluri Chaudhary, my lord, which I referred to. My lord, kindly come to page 255, para 297. Both have, my lord, held, both, my lord, 5 judge bench judgments, that exercise of power under Article 200 and as a necessary consequence 201 is legislative in nature. my lord, I have said Bihar versus Kameshwar Singh and a Valluri Chaudhary, it has been noted that the governor and the president are part of legislature and assent powers are a part of legislative process. It is in this light that the question of non-justiciability must be examined. It is submitted that once a bill is resolved and receives assent, judicial inquiry into the propriety or necessity of such reservation is restricted.
Say commissioner, don't say. Don't say it's a legislative. Governor, not legislative. Commissioner never said that.
Government or B government, the question is, my lord, as I have put it, my lord, in page 258, my lord, there are two issues. I'm not reading it. A, the 258, my lord. I'm not reading, I'm just, my lord, paraphrasing my submission. My lord, the decisions are polycentric in nature. The very nature of the decision is such that your lordships may perhaps not have any judicially manageable standard based upon which your lordships would examine. Existence or non-existence is one thing. Whether there is an assent or not is one thing. But if there is an assent would mean all options. Then, my lord, based upon what, I'm posing a question to myself, the court would examine whether this assent was rightly given or wrongly given. Second, my lord, there is a concept of constitutional committee. And the constitutional committee under our constitution is respect for one organ by the other organ. We do not have, my lord, hierarchical system that ultimately every organ's decision or conclusion would rest in one organ. There are checks and balances. For example, my lord, legislative act enactment is subject matter of your lordship's judicial review. It's not a hierarchical position, but your lordship's power of judicial review. Any decision taken by the executive, which is not a plenary constitutional power. The executive takes several decisions, my lord. The ministry, my lord, makes a policy. Ministry takes a particular decision. There are several executive functions, administrative functions. They are all subject to judicial review. But when it comes to constitutional plenary powers, more particularly of the nature which are legislative, my lord, justiciability should be denied, my lord. That is my respectful submission, my lord. My lord, on which, my lord, I am placing reliance upon one judgment, Indira Nehru Gandhi versus Raj Narayan. My lord, here your lordships have seen, my lord, a adjudication by the court by an enactment was sought to be, my lord, upturned. Please have a look at, my lord, page 258. My lord, I'm skipping through, my lord, most of the things. I'm paraphrasing it now. My lord, page 258. Para 313, my lords have.
Yes.
My lord, the Chief Justice has. Page 258, para 313.
313.
313, my lord. Indira Nehru Gandhi versus Raj Narayan. Para 577. There is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances by reason of which powers are so distributed that none of three organs is set up, it sets up, can become so predominant as to disable the others from exercising and discharging powers and functions entrusted to them. Though the Constitution does not lay down the principle of separation of powers in all its rigidity, as is the case in United States Constitution, yet it envisages such a separation to a degree as was found in Ranasinghe case, so-and-so versus so-and-so. The judicial review provided expressly in our Constitution means Article 226 and 32 is one of the features upon which hinges the system of checks and balance. Neither of three constitutionally separate organs of the state can, according to the basic scheme of our Constitution today, leap outside the boundaries of its own constitutionally assigned sphere or orbit of authority into that of the other. This is the logical and natural meaning of the principle of supremacy of the Constitution. But no Constitution can survive without a conscious adherence to its fine checks and balances, just as courts ought not to enter into problems entwined in the political thicket. Parliament must also respect the preserve of the courts. The principle of separation of power is a principle of restraint. My lord, it is not a prohibition. It is a principle of restraint. My lord, the very nature of the function, at the cost of repetition, my lord, I am respectfully urging, is such that it is entwined with political thicket. There may be 50 considerations weighing with the constitutional functionaries, for which your lordships may not have a judicially manageable standard to examine and decide whether it is valid or invalid. My lord, then next judgment, I'll read only the highlighted part, my lord. MP oil extraction versus state of MP. The supremacy of each of three organs of the state, legislature, executive, and judiciary in their respective fields of operation, needs to be emphasized. The power of judicial review of the executive and legislative action must be kept within the bounds of constitutional scheme so that there may not be any occasion to entertain misgivings about the role of judiciary in outstepping its limit by unwarranted judicial activism, being very often talked of in these days. So this is 1997 judgment.
Now we are in 25.
Now we are in 2025, my lord, and now again, my lord, this discussion is going on. And my lord, mostly, my lord, your lordship's intervention has been, my lord, for the benefit, but sometimes, my lord, it is believed that it is in the domain of executive. For example, my lord, one of the high court, since I have appeared, my lord, without naming, virtually the COVID management was being monitored, my lord, administered by the high court. And all our officers who were supposed to be working on the ground were sitting in my chamber and we were preparing the status reports. What is the vaccine available? What are the number of companies which manufacture remdesivir, which each company has by way of their raw material? What is the production capacity? What is the production capacity of each company? In how many days, how many remdesivir drugs will be made available, etc., etc., etc. So, my lord, that is something, my lord, which is avoidable.
That is micromanagement of the government function.
Well, your lordships have always, my lord,
That will never interfere with it to. We can't ask you how a district is to be administered, how your collector could function. But suppose if particular function is entrusted to the governor, the honorable governor, and if for years together he withholds it, will that also be beyond the scope of judicial review of this court?
my lord, I would say.
When this court has set aside the constitutional amendment itself, which had taken away the powers of judicial review, that no amendment should be called in question by this court, it has been found to be hitting at the basic structure of the Constitution. So, and with the judgment of, with those judgments, can we say that everything, however the highest constitutional authority may be, if it does not act, still the court would be powerless?
No, my lord. My argument, please do not misunderstand. My argument is not that the court is powerless. I am on justiciability. Lord, there is difference. There can be a power.
No, assent is given, not given. Reasons, we may not go into that as to whether the president was justified in giving the assent, as to why he has given the assent, as to why the governor has given the assent. But suppose if an act passed by a competent legislature, if the honorable governor only sits over it, that could still be the court's.
Yes, I'll answer that, my lord, in two ways. First of all, your lordships would not decide whether there is any justiciable power in your the lordship or not based upon an extreme situation, my lord, which may arise. That is my first answer. And second,
Like you said yesterday, the hard cases lay down a bad law.
bad law.
And my learned brother said that hard cases lay down a good law.
Hard cases always lay down a bad law, my lord.
No,
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 no.
no, not at all.
No such.
Lord,
they will agree with me and disagree with you.
Mr. Hari Vishnu Kamath agrees with
no,
Mr. Vikramnath
my lord, he is a very respected person, my lord, but, my lord, this is
in a lighter vein.
on the lighter vein, my lord, but this is like, my lord, a candidate celebrating based only on the Ruzan coming in the morning, my lord, and distributing sweets. That's what, my lord, the other candidate would hope, that these are only Ruzan and not the real picture. So, my lord, your lordships would, my lord, in that case, my lord, even if the governor sits on the bill, the solution does not lie here. The solution lies elsewhere.
Where?
Solution lies in the
Where?
political sphere. These are all political decisions. Such cases do happen, and such cases are, my lord, solved through that democratic process. Lord, it is wrong to believe that there can be circumstances where every other organ would fail, and therefore the only available organ would be this organ. Lord, this organ has protected fundamental rights, and your lordships are custodian of the constitution. No dispute on that. But there are certain problems which are, my lord, not solvable by the judiciary. They are to be solved, my lord, by political democratic process. When such a thing happens, my lord, we have to expect and accept that there are constitutional functionaries who are responsible and responsive because they are answerable to the people every day and at least every 5 years. In a
The honorable
situation like
governor
this,
is not answerable to anyone.
pardon me?
The honorable governor is not answerable.
Governor, my lord, I'll answer that. I'll answer that immediately. The governor is the most vulnerable office. He can be removed without anything else. My lord, the moment the chief minister goes to the prime minister or the president and look at the facts of this case, this is what has happened, and such things do happen. That when governor sits over it, my lord, for good reasons, bad reasons, no reason, whatever, then political process takes over. And governor can be called back. Governor can be, some other person can go as a governor. Why not, my lord? And why can we not trust other constitutional functionaries? It's a matter of, my lord, the chief minister talking to the other constitutional functionaries that we are facing a constitutional problem. My lord, whenever something happens, my lord, in the judiciary, I'm not giving, my lord, a comparative example. My lord, the system takes care of it. There is an inbuilt system, my lord. Every problem does not come here on the judicial side. Your lordship takes a decision on the administrative side. So every problem is not solvable under Article 32 or 226 and thereafter 136. There are problems, my lord, under, I'm sorry.
Solicitor, the constitutional immunity to some extent is clearly worded in what advice given by the governor. Polycentricity, decisions involved in such a decision making. Why an assent is given, why a withhold has taken place, and why he refers it to the president for his opinion with a message. All these stand on one footing, and there is a constitutional immunity provided to all those. But we are actually today in this case referring to the procedure prescribed, which stands on a completely different footing. As regards the procedure, where is the constitutional immunity?
There is no immunity.
Number two,
I'm sorry.
it is exactly in this very context that Kesare hymn, what you have read,
Yes.
they drew the distinction, saying that whether there is no question of deciding the validity of an assent there, but whether it was with respect to one part of it, another part of it, to examine it. They will look into it, is what they said.
That, my lord,
Therefore, an inquiry which is to be made whether the constitutional process, as Honorable Chief Justice has said, constitutional process of granting, not granting, or referring not being done, to what extent any kind of an immunity applies unendingly is the question.
my lord,
So we are not on the merits.
I'm out, my lord. I have understood the question. No, first of all, I am not basing my argument on any immunity. No, there is no immunity from judicial adjudication of any dispute except those issues which are not justiciable. I am not saying, my lord, immunity. For example, the governor takes the decision of 356. Your lordships have even hailed such decisions to be mala fide in Bihar case. In case of Bihar, your lordships were, my lord, Butta Singh. But court said that he was acting mala fide. He is not immune.
He didn't use that expression immune. We are substitute it with judicial review.
My lord, I am putting it slightly differently, my lord, not even judicial review, justiciability.
Okay, put it in, replace it with justiciability.
Yes.
Then answer it.
Yes, my lord, justiciability, my lord.
Not.
Well,
And
justiciability,
there
my
be a
lord, flows.
constitutional logjam then. And there be a logjam.
My lord,
You are saying that the only way to answer it is through political process.
my lord, every logjam may not have a problem, may not have a solution with the judiciary. My lord. I'm with profound respect, kindly don't take this as an arrogant way of, my lord, putting it. I'm saying constitutionally, every problem may not have solution before the court. There are several problems where the problems will have to be sorted out as per the constitutionally prescribed democratic political process. And the court would be, my lord, holding its hands, my lord, saying that it is non-justiciable. We do not have any standards by which.
Our powers under 356 are for a temporary period. The president rules cannot be.
It can't be.
Then there are inbuilt safeguards.
Correct, my lord.
Within a limited period, it has to be placed before both the houses of the parliament.
Correct, my lord.
Then, if there is a dissolution, then
Election within a.
after 6 months, so in under 200, if we hold that the honorable governor has an unlimited power to withhold for time immemorial,
I'm just, my lord, just allow me to make the distinction. Article
then
3.
what is the safeguard for a duly elected legislature? Suppose a legislature which is elected by, say, 2/3 majority unanimously passes a bill. And we were giving example yesterday that if it is repugnant with the central act, then he may withhold it, or for some other reason, national security, so and so. If that be so, then if he doesn't exercise the proviso, it will be making the legislature totally defunct. The persons who are elected from that state, and if such a, it is not as if such an act is repugnant, then it is always subject to challenge. Or if it is contrary to.
Lord, may I answer? May I answer? Well, 356 is an executive power. It's not a legislative power, first of all. my lord. And therefore, my lord, there is.
To be ratified by the legislature, central legislature.
No, correct, my lord, but that's not the question here, my lord, is the decision taken in exercise of executive power under 356 is subject matter of judicial review. My lord, again, my lord, your lordship's concern is a concern that what happens, but the answer is this forum is not the solution. The solution is either amendment of the constitution, and till that happens, the political process, and such process does take place. Every state does not take a confrontation position. My lord, they do, my lord, exercise their my lord, diplomatic options, meeting, my lord, the constitutional functionaries. They persuade, my lord, discuss, debate, if there is some gap between one thinking and another, they try to bridge the gap and ultimately the problems are solved. Your lordships are not flooded with state government saying that my bills are pending. So therefore, I am, my lord, repeatedly cautioning, my lord, not to examine the matter based upon some extraordinary or exceptional situations. Lord, now, my lord, I'll again come back to, my lord, page 259, my lord. State of Rajasthan versus Ramesh Chandra Mundra. Because here again, my lord, we would be creating a constitutional hierarchy that ultimately every problem will, the buck will stop here only, or for every problem in the country. Which is not, my lord, in my respectful submission, my lord, the real heart and soul of the separation of power. Some problems are problem of a nature where the solution cannot be here. My lord, please come to, my lord, page 260. My lord, Kalpana Mehta. My lord, it again, my lord, talks of the separation of power. My lord, I'll not repeat it, my lord. I may not repeat it. Please come to, my lord, 264. And I'll just read two paragraphs and, my lord, move on. My lord, I have already pointed out that there are certain core functions. Core functions. My lord, there are, for example, governor exercises several powers. But there are certain functions which are core constitutional functions in the nature of a legislative function. My lord, there, the doctrine of separation of powers, my lord. My lord, the problems, I kindly pardon me for giving this, my lord, example. It may not be a comparable example also. My lord, Supreme Court decides 100 cases, hypothetically, my lord, per month. There are several cases where they are changed in the curative jurisdiction. There is a possibility that even after curative decision, jurisdiction being exercised, some may feel that still we have not got justice. Somewhere, something will have to stop. The buck will have to stop somewhere. Look, the justiciability argument being met with that what happens if this situation arises is, my lord, in my respectful submission, my lord, ignores an argument that in every sphere of the constitutionally framed three organs, my lord, there are some issues where buck will have to stop somewhere. It need not be, my lord, it need not reach here, my lord. I'm sorry, my lord. I'm trying to phrase it the way it is possible. My lord, now kindly see, my lord. I'll skip, my lord, the rest of the things. And please come to, my lord, Aravalli Golf Club. My lord, I'm now on, my lord, other directions which are given 3 months period, give reasons. My lord, the Tamil Nadu judgment, the 3 months time fix, give reasons, and deemed assent. I'll come to, my lord, last point is deemed assent, whether there can be any conceptual concept of a deemed assent or not. And I have also enlisted the provisions wherever the Constitution stipulated that in absence of a particular act, something will be deemed, the Constitution has provided. My lord, there is one beautiful passage, my lord, in Aravalli Golf Club versus Chendarhas. My lord, please see, my lord, the highlighted part only. Page 272.
270.
272.
For the deem, opposition on deem?
No, my lord. Justiciability.
That's true.
Lord, restraint, judicial restraint, that every problem need not be solution here. My lord, they have used, my lord, one very popular statement of Justice Cardozo. Judges must exercise judicial restraint. Your lordship, Simon. Judges must exercise judicial restraint and must not encroach into the executive or legislative domain, vide so and so, Under our constitution, the legislature, the executive and the judiciary all have their own broad spheres of operation. Ordinarily, it is not proper for any of these three organs of the state to encroach upon the domain of another. Otherwise, the delicate balance in the constitution will be upset and there will be a reaction. Judges must know their limits. I'm sorry, Mala, I'm reading the judgment.
Yes, yes, yes.
Must
You can read it loudly, no difficulty. Yes.
Why you feel sensitive? If you don't have to,
Judges
then we
must
don't have.
know their limits.
Yeah, we also say that whenever a petition comes before us,
Your lordships have always, my lord,
That it is
the
the-
separation of power is, my lord, kept in.
yeah, whenever we don't want to name the petitioners, issue such direction to the Union of India to frame this law. We always say that it is within the domain of the legislature, it is within the domain of the executive.
Serial litigators, my lord, as I say.
Something is done and the first petitions are filed with 2 or 3 pages and so
Yes,
therefore,
my lord, so that the reported judgment,
so therefore the then Chief Justice came with this policy in race one. So
Ray so and so.
otherwise,
But that was suggested by me, that because there used to be a fight, that mine is filed first, but his petition is registered first by the registry. So, so therefore I suggested that instead that it should be Ray so and so. Judges must know their limits and must not try to run the government. They have modesty. But don't kindly ignore it. 21. The
no,
theory
you
of-
can read that. No, don't.
The theory of separation of powers, first propounded by the French thinker Montesquieu in his book, The Spirit of Laws, broadly holds the fill in India too. In chapter 11 of his book, The Spirit of Laws, my lord, I can skip Montesquieu. Kindly turn the page over, my lords. I'm sorry, my lords. My lord, page 274, para 30. Para 30, your lordships, my lords.
Yes.
The justification often given for judicial encroachment into the domain of the executive or legislature is that other two organs are not doing their jobs properly. Even assuming this so, the same allegation can then be made against the judiciary too, because there are cases pending in courts for half a century, as pointed out by this court in so and so. If the legislature or the executive are not functioning properly, it is for the people to correct the defects by exercising their franchise properly in the next election and voting for candidates who will fulfill their expectations, or by other lawful methods, that is, peaceful demonstrations. The remedy is not in the judiciary taking over the legislative or executive functions, because that will not only violate the delicate balance of power enshrined in the Constitution, but also the judiciary has neither the expertise nor the resources to perform such functions. Well, kindly turn the page, para 35. The constitutional trade-off for independence is that judges must restrain themselves from the areas reserved to other separate branches. Thus, judicial restraint complements the twin overarching values of the independence of judiciary and the separation of powers. In Lochner versus so-and-so, Mr. Justice Holmes, in dissenting judgment, criticized the majority of the court becoming a super legislature by inventing a liberty of contract theory, thereby enforcing in particular laissez-faire economic philosophy. My lord, kindly skip some my lord, part. In the nature of judicial process, Justice Cardozo remarked, and my lord, this, my lord, in my respectful submission, has withstood the test of time and is being quoted often. Justice Cardozo remarked, the judge is not a knight errant roaming at will in his pursuit of his own ideal of beauty and goodness. My lord, in Maratha reservation, my lord, also, this is cited. My lord, knight errant, my lord, is kind of, it's a fictional character which used to roam around at night, and whatever he thought is improper or illegal in the society,
Robin Hood.
he would correct it. So therefore, they say that this is something which should not be done. My lord, kindly skip the pages, my lord. Page 282. Lord, one organ of state cannot arrogate to itself the functions of another organ. My lord, this is, my lord, when we say if you don't do it within a particular period, there would be a deemed assent, or we would examine whether you had justification of not doing it in a particular way, not doing it on a particular time, etc., my lord, would be violative of, my lord, separation of
Then
powers.
Para 38 also,
Para, my lord, 353.
38, page 275.
Oh, I'm sorry.
Moral of the story.
Page 27. I'm sorry. Para 38. The moral of this story is that the judiciary does not exercise restraint and overstretch its limits. There is bound to be reaction from politicians and others. The politician, I avoid it. The politicians will then.
Why avoid it? It's in a print. Yes. It's in a print.
Lord, sometimes, my lord, politicians
Barely because Mr. Sibal and Mr. Dr. Singhi are here, it doesn't mean that we shouldn't read that.
No, they're respectable politicians.
So they are in the dual capacity.
No, even Mr. Wilson is here.
Yeah,
Was
Mr. Wilson is not to be
And,
seen.
um,
Mr. Reddy is also
Mr.
there.
Reddy is here, my lord. We have 3 MPs.
He was remarking, my lord, when he was mentioning about the parliamentarians, if Dr. Singhvi would be here when Wilson was there would have been 4 of us in a row.
And despite the parliament being in session, 4 of them are here.
That is how Parliament is adjourned now.
On the lighter side.
So the moral of the story is,
More- let it, your lordships have read it. But why? Well, I'll read, but there is nothing. The moral of the story is that if the judiciary does not
May I
exercise.
just interrupt for 30 seconds? Because there is this about this parliament and this. Because Mr. Jaitley and I were coming out of the house, and Mr. Yechuri was also coming out. He had just given a speech in parliament asking for a law to prohibit doctors, lawyers, chartered accountants, and anybody else to be MP. So when we came out, both of us spontaneously told him, we said, Sitaram, you want parliament to be a community of unemployed and unemployables. This actually happened with us, and all 3 of us are together.
Lord, I was on page 282, but please come to page 283. Lord, State of Rajasthan versus Union of India. Lord, this is a 7-judge bench judgment. my lord.
Mumbai total threat. Mumbai.
But this is precursor to Bomai. Bomai I will not read. I'll just, my lord, paraphrase why your lordships would not rely upon Bomai, though Tamil Nadu relies upon Bomai. Well, just a bold part, but it cannot assume unto itself the powers of constitution lodges elsewhere or undertake tasks entrusted by the constitution to other departments of the state which may be better equipped to perform them. The scrupulously discharged duties of all guardians of the constitution include the duty not to transgress the limitations of their own constitutionally circumscribed powers by trespassing into what is properly the domain of other constitutional organs. Questions of political wisdom or executive policy only could not be subjected to judicial control. No doubt, executive policy must also be subordinated to constitutionally sanctioned purposes. It has its sphere and limitations, but so long as it operates within that sphere, its operations are immune from judicial interference. This is also a part of the doctrine of rough separation of powers under the supremacy of constitution repeatedly propounded by this court, and to which the court unswearingly adheres even when its views differ or change on the correct interpretation of a particular constitutional provision. Then bottom, a scrupulous adherence to this scheme is necessary for the smooth operation of our constitutional mechanism of checks and balances. It implies due respect for and confidence in each organ of our republic by the other two. My lord, particularly when, my lord, we are dealing with the highest constitutional functionaries of coordinate organs, my lord, in their constitutional capacity. my lord, not in their executive capacity, in their plenary power, which is legislative in nature, my lord. My lord, similar are other judgments, my lord. I am not troubling your lordships with, my lord, may be treated as read, my lord. My lord, thereafter, my lord, I have said, Lord,
Even Bommai is not completely against you
no, it's not.
because.
In fact,
Even read this judgment in fact.
it says there are manageable standards.
Specifies what are outside the ken of.
Exactly, my lords. I'm grateful.
Some portion.
I'm immensely grateful, my lords. My lord, I have said, restraint in exercise of judicial power in case of high constitutional functionary is a facet of separation of powers, which is a basic structure of the Constitution. And therefore, such restraint and non-justiciability should be read as a part of basic structure of the Constitution, to respect the separation of powers. My lord, then page 285, that even when there are undisputed judicial review positions, my lord, that legislature, executive policy, etc., there are inbuilt self-imposed restrictions, my lord. Judicial restraint is always a self-imposed restriction. My lord, now page 287, my lord, your lordships must have these judgments. I am not reading them, but world over, these are judgments from other jurisdictions.
But you always say that we should.
I am not reading them.
Should only follow our jurisdiction.
Yeah, absolutely. Well, therefore, I said that your lordships must have it, but without going into it, my lords. Lord, Thames cannot be more pious than Ganga, my lord. That is or Mississippi for that matter. Petoma, my lord.
What is
Washington has Petoma. Anyway, my lord,
Krishna.
In the concurring opinion
in some concurring opinion of Samsher Singh, my lords. Lord, now please come to 304. Quote किया. Lord, I'll not trouble your lordships because propositions are known. Lord, there are three judgments cited in Tamil Nadu case for the purpose of justiciability. First is Bommai case, as my Lord Justice Narasimha has said, my Lord, and I respectfully, my Lord, take that, my Lord, that there the Honorable Supreme Court came to a conclusion that there are judicially manageable standards. This was not a case of assent. Bommai was a case of 356. And therefore, it was an executive act and there were standards, whether you could have done it or you could not have done it. And therefore, the judicial review was exercised. My Lord, I have quoted the relevant paragraphs of Justice Ahmadi, Justice Verma, Justice Yogeshwar Dayal, my Lord, but I don't wish to read them. My Lord, second judgment which is cited is, my Lord, Manipur Tribunal. My Lord, that 10th schedule. Lord, that again, my Lord, Speaker is a tribunal and therefore there is no dispute that he is amenable to judicial review. He is not functioning inside the house or as a leader of the house while he discharging functions as a, my Lord, adjudicatory body under clause 6 of the 10th schedule. And another judgment, my Lord, which is cited, which is relied upon by Tamil Nadu judgment, is Maruram and Perarivelam. That if we can have judicial review over that function of the president, why not this? My Lord, Maruram and Perarivelam were cases where the Honorable President exercised purely executive act of pardon, which is subject matter of judicial review. And it was a case of Article 21 of a citizen. It was not, my Lord, a political question that way. Political, not in, my Lord, any derogatory sense. Political questions means questions arising out of functioning of a functional democracy in a quasi-federal constitution. My lord, so these three judgments, my lord, would not lead to any conclusion that it is justiciable. My lord, Oyst and Kaiser, my lord, in my respectful submission, holds the field. Then your lordships may, my lord, kindly come to Lord, page 321. Lord, 321, my lord, raises question number 9. Raise, my lord, which the Honorable President has, my lord, sought your lordship's advice, is this. Are the decisions, my lord, page 328, 321, sorry.
Yeah.
Are the decisions of the governor and the president under Article 200 and Article 201 of the Constitution of India, respectively, justiciable at a stage anterior into the law coming into force? Meaning thereby, my lord, this is a subset that it is still at the stage of grant of assent, withholding of assent, returning the bill, etc., etc. Can someone come and say that this act under Article 200 and 201 is unconstitutional? My lord, please have a look at, my lord. Para 410, my lord. Lord, I would only read.
Act under 20. Under 200, there is no act, still at the bill stage. So only when the assent goes, the act, and then, of course, act is.
Then the bill can be challenged on all grounds possible. Pardon, my lord?
Exercise of 200.
Yes, yes, ma'am. Act capital A.
But-
Yes, yes, ma'am.
But if there is no decision, you have framed the question. Are the decisions of the governor and presiding president under Article 200 and Article 201 of the Constitution of India, respectively justiciable at the stage anterior into the law coming into force?
Yes, ma'am. My lord, but law comes into force when
Assent is granted.
is granted. But before that, it should have been granted, should not have been granted, should not have been referred to the president, should not have been returned to the house. Because here, my lord, we have faced a case where at that stage, my lord, the court has said that assent is deemed to have been granted. Then this is possibly, my lord, for the, not possibly, 100%, first time where the act came into force with the assent granted by the Supreme Court of India. My lord, your lordships on this side and on that side have seen acts which starts with this bill having been assented to by the President or Governor of India with a order dated so and so. My lord, these acts in Tamil Nadu mentions in the Gazette the bill having been assented by the Supreme Court of India with a judgment dated so and so. The court has exercised its jurisdiction at a stage anterior to the law coming into force. That is, my lord. And only see, my lord, one para, my lord, 414. My lord, your lordships would now again go back to Quixote. Quixote judicial review is available. Correct, my lord? No dispute on that because Speaker is a tribunal. Still, 5-judge bench in Quixote says that no qui timate action is permissible. We can finally set it aside, but we can do nothing at an interim stage. My lord, please have a look at
That
this.
has been interpreted that any such order which prevents the speaker from exercising his powers would not be permissible, but any order by the court which enables the speaker to proceed further would be permissible.
Yes, yes, yes.
That Kama David has been interpreted in so many judgments.
Yes, yes, my lord. But my lord, point I am trying to make is that even where judicial review is undisputed, it is at a stage where the action is performed, the order is passed. Lord, please have a look for my satisfaction, page, my lord, 322, what my lord Quixote Holohan says, my lord, on this. Pehla 110, only one para is, my lord, relevant.
Tamil Nadu was a reverse case, Mr. Solicitor. Here the complaint was that action is not being taken. That was completely reversal.
Correct, my lord, that is justiciability, whether court could have done something or not. Correct, my
No,
lord.
no, so, therefore,
My lord,
we,
this,
we are not in an appeal of the judgment.
I am not,
Suppose, what is in our minds from day one? If for 4 years,
my lord, that your lordships will have to remove while answering this question. My lord, your lordship's interpretation cannot be based upon one particular instance.
Honorable CJI is asking on hypothetical case. That suppose there is a, it's not in one state.
and you are saying that it's, at least I think we are having petitions from 2-3 states now.
Yes, yes, yes.
Kerala, then
West Bengal.
West Bengal, then Punjab.
Yeah, I was missing you.
Yes.
So I was.
How can he be missed?
You here? No, there are fixed seats.
No, you objected to his petition on Monday itself, so.
Yes, yes. And your lordship now knows why they were opposing reference to a 5-judge bench.
But then we said that whatever we decide here,
Certain.
will
I am
affect
on
all
that.
these
That
matters.
was on the lighter side, nothing to turn on the merits.
The fallacy of this
No, we quite appreciate whether a time bond program could be issued such a 3 months, 1 month, and then deemed and all that. But consider a situation where the governor is bound to either way grant asset, but if for 4 years just sits over, then what happens to the democratic setup of the government? What happens to the will of 2/3 of the majority of the legislature of that state?
I would not, my lord, like to answer, my lord, answer the way I am going to answer. But suppose, my lord, the precedent, my lord, as I'm at the cost of repetition, is
We are not talking about President, Honorable President, we are talking about the governor.
the governor. I'm giving an example of a president of India where a citizen approaches him that my trial is pending since 10 years and the sessions judge is not taking up the matter and my offense is punishable with only 7 years of imprisonment and my husband is in jail. Can inaction on part of the judiciary empower the president to declare him as having only undergone the sentence? It may not be a comparable example,
We don't
but
think
this is
there are
how separation
any
of
para-
power.
that exactly.
This
We
is
feel-
how separation of power. This presupposes that every problem will have a solution only ultimately at the doors of this court. And political solutions or democratic solutions are no solutions. There are solutions, problems in functioning of the constitution where there may not be a solution necessarily by judicial adjudication. It's not necessary, my lord, to hypothetically believe that every solution.
No, we are not hypothetically believing it. We are having petitions at least from the 4
No,
states.
I am saying something else, my lord, that necessarily presuppose a belief that ultimately we will have to solve every problem. My lord, and my respectful submission is there are problems where this may not be the only solution or this may not be the solution. That's my respectful submission. I'll proceed further.
like, for example, how political executive came up with 10 schedule. It's not a court's invocation. That's what you said.
Yes, ma'am.
10 schedule.
Parliament did it because there was a problem of ayaram, gayaram, as we say. Defection was rampant.
The preamble itself, preamble of the constitutional amendment itself begins with that problem.
Correct. So, my lord, some problems, the solution can come only from within the system. That is, my lord, the doctrine of separation of power. There are certain core legislative functions, there are certain core executive functions, there are certain core judicial functions. But at the moment executive tries to step in, the judicial domain, your lordships have restricted. And rightly so, on the ground of separation of powers. Well, that is how NJSC went. NJSC was declared illegal. The entire political spectrum of the country was on one page. Unanimous. It was passed unanimously, ratified by the two-thirds of the state, but your lordships protected the separation of powers. That no, one person also from the executive would not be a part of the collegium. My lord, respectful submission is, my lord, the separation of power is a balancing act which balances the constitution. And it will have to be a two-way street. Some issues are non-justiciable, but that's the respectful submission. My lord, kindly come to 324. Is it permissible for the court, my lord, please 324, and I'll just, my lord, orally argue, but I'm not reading it. Is it permissible for the courts, and this is a very, very important, my lord, question which the Honorable President wants your lordships as, my lord, guidance on. Is it permissible for the courts to undertake judicial adjudication over contents of a bill in any manner before it becomes law? My lord, why this question?
I
is
think,
there?
It is that question, it doesn't.
I'll
arise
tell
as
your
a-
lordships why it has arisen. What is, my lord, the scheme of the constitution? The governor assents the bill, withholds the bill, or refers it to the president. Forget two options. Forget fourth option. He refers it to the president. The question has arisen where there is a two-judge bench judgment which says that it is prudent for the president, before granting assent, to make a reference under Article 143 of the Constitution to this court, because the question of repugnancy is a legal question. Meaning thereby, the president will come before your lordships by way of a reference that I have received these many bills from the state. Kindly take that direction. And it is otherwise imprudent for me, as the Supreme Court has said, to take decision on my own, and therefore I am now requesting you to tell me whether it is repugnant or not. It proceeds on two fundamentally flawed assumptions. A, the Honorable President, or in this case, Honorable President, is unable to decide for herself whether there is repugnancy or not. And number two, your lordships will examine the bill at a stage anterior to it being an act and decide whether there is any repugnancy or not. And if your lordship says no, you grant assent, then the president will grant an assent. My lord, do we have a dual structure where before granting assent to a bill, unless the president is herself or himself, my lord, is of the opinion that we need opinion? My lord, there are two or three references made on the bill that I would like the Honorable Supreme Court to examine and guide me. But otherwise, do we presume that president will not be able to on her own take a call, and therefore it is prudent that president in every case comes before the court under a reference with 143, my lord. I'll just read it, my lord. Your lordships need not open. Whenever in exercise of powers under Article 200 of the Constitution, a bill is reserved for consideration of the president on grounds of patent unconstitutionality, they are of such a nature so as to cause peril to the principles of representative democracy, the president must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon the questions of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the president ought to make a reference to this court in exercise of his powers under Article 143 of the Constitution. So before the bill becomes an act,
This is, that's question number 12. We will examine that 12 in that context. But this issue relating to examining the bill at a bill stage is consequence of that question. This question doesn't
12.
stand on its own. This 12 doesn't stand on its own for the reason that nobody
No, because
is asking
He
the
has
bill to
framed
be
that
examined.
question, he has framed that question because of those observations.
This is it's coming before.
Before the president decides whether to grant assent or not,
Lord,
he should give our.
Lord, kindly see,
Consequence of.
Answer is the wise one.
My lord, kindly see the, my lord, hazard of this. Now, kindly see the hazard.
would readily agree with you that what should be the answer to that question?
Kindly see the hazard. My lord, kindly see the hazard. I'll give a simple example, my lord, and there is no answer to that example.
I don't think that they would be opposing.
They would be, my lord. Let me place it. Let me place it. My lord, suppose
Civil as
they should,
already was fine.
my lord, they should not, because it's not A government or B government.
No, no, rewriting the constitution.
Yes, my lord. The difficulty would be this. My lord, if in every case the president as
Then we'll have to leave all other work and only devote ourselves to giving advice to the Honorable President under 143.5,
not the
145.3.
Lord, the difficulty would be, it would be a matter between your lordships and the president. There would not be anyone else. Your lordship says that no, there is no repugnancy.
No, but then under 145.3, we have to sit in a bench of 5 for giving that opinion.
Minimum 5. Minimum.
Minimum 5 years.
Minimum 5